I think the debate we are doing is relevant to a lot of communities that may or may not be represented in this room, because really we still are privileged. We have access to resources, to ideas, to influence, to capital, but in the sense that we are the people who are responsible for shaping a view on this issue. In terms of some of us have the influence to be able to bring about a change. So in that sense, it's the right audience. But I think taking this debate outside this room to people who in some way are recipients of the justice or not the recipients of the justice in this context may help. So maybe organizing it in smaller cities, partnering with newspapers in local languages would be a solution to kind of building a public opinion. Now the problem of land use stems from the fact that the property right holders are instigated to sell their properties at basically low rates. You know that the modus operandi is that the after that has happened, the government then suddenly announces that the area is valuable and the prices go up. Some development comes around the area, it's included in the master plan. So really there is a collusion between the policy makers, the land mafia, the intermediaries, and a set of owners. This cannot happen without the involvement of some landowners. So that's really the problem. And the builder beneficiary sells the land further to consumers of the land in the shape of houses, plots, or to developers to co-develop. The original owner of the land, when he or she comes to know about this, acts and produces the case in court. He or she feels left out. The case is prolonged and the two parties get affected the most. The original owner, who is worst off, and the customer who has bought the land from the builder are really the two, so to say. I mean, everybody loses in the short term, but really these are the two people who lose most. The Indian court system delays the process and the outcome is negligible over the years. Several cases in respect of these issues have been reported in the past, and I could give you some high profile examples, but the top builders have really continued to accentuate this practice where land is being acquired from property owners and then is being sold. Now, if you look at it point by point, how the modus operandi is, the agriculture productive land is termed as non-productive by the government after a series of processes which are in my view laden with corruption and collusion. The land is then sold off at dirt cheap price to the beneficiary. The government serves as a corrupt middleman, knowingly or unknowingly. I can't say that the government acts knowingly. There are a set of laws, there are individuals that may. So I won't say the government, I mean, Dr. Kapoor has his viewpoint. I do not subscribe to all his views. The land is developed in parcels of development areas and is sold off, and the original owner of land gets worse off than he originally was, because the money that he or she makes gets used in things that may or may not be productive. We have examples in Haryana, and the builder and the intermediaries really benefit from this transaction. Now again, we can keep criticizing the government, bureaucrats, this country, God, but really look at solutions. Let's look at what the world has done. And again, Singapore is a right example. It's a good place to take inspiration, but it's a tiny nation, and it is in some way I wouldn't call it a dictatorship. There is a benevolent dictator there, right? It works. The rules were laid 45 years back. They are followed. So I think we are way down the road. I think, yes, we can learn any good thing from anyone, but to use it as an example and say we should be like Singapore, I think it's good to talk at conferences, but it may not happen. But the solutions may be land pooling and readjustment. And I want to give you an example from urban Delhi. The principle here being that the underlying land pooling scheme is to aggregate the land required for a project, not by displacing and compensating the specific owners of that land, but by getting a larger group of adjacent landowners to make room by contributing a portion of their land parcels to a common pool in a manner that no one is displaced and all get to benefit from the project as it goes forward. For example, I would like to give you a tangible example of this. The Sardar Patel Ring Road in Ahmedabad is an excellent example of this. Land readjustment schemes involve the use of land for land swaps or other mechanisms for exchange of property ownership rights, that may also lead to aggregation of land. The idea is again to minimize displacement and eliminate the need for cash compensation, so that there is an upside for the landowner in the project. Under these schemes, landowners are typically provided service land of similar value to what they part with. In countries where private property rights are strong, for example in Japan, or the definition of public purpose is narrow, as in Israel, land readjustment is the only way to acquire land for development projects. I want you to give you these examples of Japan and Israel. We are somewhere in the middle. There needs to be a stringent checking mechanism before a land is shifted from one party to another with all stakeholders on board. Government of the day needs to ensure that there is no corruption. Now that's too much to ask from the government immediately. I'm not suggesting that we can't make a change, but I think all these stakeholders benefit, and hence the corruption is endemic of our society. So it's not just limited to this specific area. Amit alluded to the fact that what is the deterrent for doing this? Stringent punishment and fast-track court procedures are another way of handling the problem, but this is dealing with this problem in a selective manner. To curb the root, there has to be a significant change in the land acquisition bill. So these are, now when we talk, I was reading this and I was reading where India is, and again one of the solutions that was proposed is in some way using the technology. Today we live in an era of technology where it is very easy to classify property records, but if we can create, we are talking of a UID, we are talking of, technology impacting every area of our life. Now property, if we can create land records, and I was reading the brief case study of the Honduran land titles, and Honduras doesn't do well in the IPR rankings. If we just took that as an example and were able to implement that, it would help. It's a complex issue because it involves many domains. It involves judiciary, it involves, a policy change. And I want to go back to 1991 when Narasimha Rao was the Prime Minister and Dr. Manmohan Singh was the Finance Minister. And really whatever we see in terms of economic liberalization that happened. But it took a strong political will. Dr. Manmohan Singh was of course the thinker, the policy maker, but it took a political will from the then Prime Minister to be able to push that. I think today, if something like this has to happen, there has to be a political will, because it hits out the interests and change is really resisted. The other thing is, on a philosophical note, today we live we're moving from ownership to experience to consumption. In every domain, car ownership, I'm seriously think, do I really need a car and driver anymore? I should order the ride sharing services. Why should I spend so much time on trying to argue with my driver and, dealing with him and maintaining a car? So overall, we are moving from an economy where ownership is important, but experience and consumption probably dictates. Ownership is not that important. So how can we create access? So we are moving from ownership to access. Now, till now in India, the land rights, which are a fundamental right in my view, haven't created access. So can we from this panel come out with a solution which creates access? I'm not saying dilute the ownership, but sometimes the ownership exists, but the access doesn't happen. And access creates benefits, economic benefits. So really I would like this panel to be solution oriented and give us very practical solutions. I remember I built a small media company called Exchange for Media, and I used to be in Kailash building, and I was on the 12th floor, and there was a person who used to work on the 5th floor in an office, and he became pally. And he came to me and he said, I have an idea to solve India's problem. And he said, let's create a cess. He proposed an idea of a judicial cess, which will go in making sure that the number of judges is more, the judicial system has more decision-making points, the cases are not clogged, and that money the government should not be able to use for anything else. It has to go into, because if that happens, then the rule of law is implemented, there's a deterrence, because right now, really, the root cause is that our courts take time and we know the reasons why. So he said if we can do that, every problem that affects this country can be solved. And when I was coming today for this conference, I was thinking, is that the solution? Because we can talk about all the things that the last panel talked and what the panelists will today give us in terms of solutions. But really, to move that needs political will. It needs thinking. And again, I want to make my last point. Again, when we're thinking of property as a fundamental right, we cannot ignore the social milieu of this country. Again, there is some correlation I was reading to gender equality and property rights, and how education in that country has correlation with the education levels and so on and so forth. Again, we are not thinking 10, 20 years ahead. I mean, property will always be valuable. It is a basic asset for economic gain and hence advancement. But really, we are again talking of a sharing economy. We are talking of technology impacting us. Maybe 5 years from now, bots would have taken up a lot of our roles. I mean, today in journalism, you can create stories through algorithms, where bots can write stories. You put data and there is, and I'm not exaggerating, yes, it may not bring the point of view, it may not bring the emotion, it may not bring the, a belief in a certain philosophy. But, technology is going to impact us. And in the US, manufacturing has gone up, but the number of jobs hasn't increased because it has become mechanized. Robots have taken over manufacturing. Now, similarly, who thought sharing services would be so prevalent in India? But they have come. In 5 years, 10 years, 7 years, I don't know. There'll be driverless cars, in my view. I don't know when, 3 years, 5 years, 10 years. But driverless cars will come to India also in some time. Are we thinking about the social dimension? In the last 2 years, 3 years, we created these very affluent drivers who make more money than some MBAs from C-class institutions make. What will happen to these drivers? Tomorrow if technology impacts education, and we're talking of MOOCs, and MOOCs is right now on the fringes, right? Technology is impacting education. What will happen to our teachers? How do they need to kind of reorient? In that context, if when we implement technology and we are able to use technology to be able to have a single verifiable land records that really are in some way the guiding principle for ownership, are we thinking of what will happen to all the disputes that have happened till now? How does it impact all the stakeholders that currently are engaged in some kind of discussion, litigation? How do you solve that? Going forward, of course, we know we'll be. So I think we have to think of social dimension of all the solutions that we provide. With that background, I'd like to bring our panelists. Vikramjit, we can start from you.
Is because this entire question of which hangs over every liberal property rights conference is what happened to the fundamental right to property, which was in the Indian Constitution, which was taken out and has been put into a place which is called constitutional rights, 300A. And no one knows what a constitutional right is. The courts are confused as to what the constitutional right is. And considering at the present moment there is so much politics over land and property and acquisition of property, where does that leave fundamental rights? So before I start, it's very important to contextualize it. The first point which I want to bring forward is the global history of property rights. The property rights actually came into being, it's first exemplified, as we all know, in the Magna Carta, where it was a very different sort of property which was recognized. The property of the lords as compared to the king was recognized. Now, everybody who ever has read the Magna Carta, it's a very specific property, the claims of and the recognition of the rights of the barons as compared to the king, who was supposed to own all the land. So Magna Carta could be taken as a first step. Next big development in sort of property right as we know today was the American Revolution, where it was sort of escape from feudalism and creation of what we know today as largely private property rights. That is the abolition of primogeniture and the right to hold property in perpetuity. So it was the formation of the first sort of the property rights, individual property rights as we know it today. There was a huge difference, and it was an example of American republicanism that they got rid of all the feudalism part of it. It was a very specific ideology, and there was a lot of literature written at the time of the American independence saying that along with American independence we have to bring in republicanism, we have to get rid of British feudalism, and the property rights were so structured so as to make it more individualistic. There was a lot of thinking at that point of time. John Locke had written about it. So, and this was exemplified in the American Revolution and subsequent developments in American law in relation to property rights. In France, there was an attack on the property from the society's perspective. Now, the first was, the Article 17 of the Declaration of the Rights of Man, where Robespierre actually spoke about that you have to ensure that property rights, you can't have property rights at a place which will affect the poor. Now, anyone who knows the history of the French Revolution will also be aware that there were two types of citizenship which were created at the time of the French Revolution. One was people who held property, they were the active citizens, and there was the passive citizens, people who did not hold property. So Robespierre at that point of time was the first big criticism of this entire division, saying that property rights should not work against the poor. But the more sort of concrete socialist sort of criticism came from Diderot, who made that famous comment that property is a manifestation of avarice, and what property actually means is it leads to exploitation and is therefore the highest evil. Now, that is all well said for Europe, but this is where the coin fell. We had a society for, I think, 5,000 years or 4,500, and we had property. A society can't function without property. So when these really enlightened people from Europe came over to India, they decided to reorganize all property systems and say, all you don't know how property is to be organized. Property now will be organized in terms of what we are going to organize property as. So they whole scale destroyed the old property systems. This happened in all colonial, wherever the colonies were set up, whole scale, completely. Ranajit Guha, who's subaltern studies expert whom you may have heard of, had a study on the dual taxation system in Bengal, whereby the British actually went through a policy whereby they destroyed the old landholding system and instituted their landholding system so as to ensure that there was maximum revenue which could be extracted. So as a result, what happened is the entire old landholding system was got rid of, and a new class of people were created. All the zamindars, the talukdars, people who would extract the benefit of the property and deliver it to the colonial masters, from where it could be sent off straight to Europe. Now this created complete mayhem within these colonial societies. Now again, with the rise of communism, Russia, China, there was a large-scale abolition of the right to property, but in most cases, even in Russia, even in China, property was envisaged as a benefit of the rich. Even fascism and Nazism, they tried to restrict property. It was in the interest of society, you restrict property. Now, in the third world, in 50s to 80s, there was a spate of nationalizations which were perceived to be extension of anti-colonial struggle. And the reason why they took up their stand against property is because property was envisaged to be close to the people in power. Mixed economies in the world, like India post 1990s, needed land. 1990s, there was the collapse of communism. And property rights became the touchstone of democracy and free market. So then that's when all these property indexes came into being. Then people started saying that if you have right to property, the more you have an entrenched right to property, the better it is for a society. Now, this led to problems for people like India. When you have mixed economies in the world, so at post-1990s, you need land for development, expansion of industries to leapfrog into the developed countries, but land is difficult to get. So there is now a conflict and a return to right to property. But this is where the coin, or whatever the coin turns, is not as a privilege of the rich now, but an instrumental resistance of the poor. And that, if anyone goes through the American Revolution and all the historic thinking about the right to property, will realize that is what it was always. It was the tool of the little person, and not the benefit for the rich. And that's what the right to property now today, if anyone goes through the Supreme Court debates, that's what it has now come to signify. Now here is, so that to contextualize the whole thing, is what were the Indic conceptions of property. The Indic conceptions of property is basically what was called satta, that is ownership, roughly a claim on property, and could be traced back to Jaimini and back to the Vedas, for the want of a better source right at the present moment. Property could be acquired by either purchase, getting, buying, and or exchange. And here is the difference. Swatta is absolute, but one amongst interlocking rights. And your satta may be subject to other rights and claims. So it could be paratantra, which are completely independent, like the Raja, like the Guru, like the Jati, the Kula. Anyone who knows India will know what, Raja is the king, the Guru is the Guru, Jati is your group. The want of a better word, caste, is we use caste very informally, but Jati is not caste. Kula is your family. But these were all swatantra. These were independent rights. Every one of those rights were independent, but they were not hierarchical. They were sometimes equal, they were equal, sometimes even contradictory. Like, let's say, the right to co-personary in a joint Hindu family. So every person who were in the family had an equal right. They were sometimes contradictory. And there was the right of the person with the karta, who was the head of the family. Now all of them had rights, and all of them had claims. None was more important or hierarchical than the other. The karta could not say that no one else would get a right in the family property. Now, the group which recognized property as property in the West was the state. The state recognized this is property and you could sell it. In India, so the king at no point of time had eminent domain. The transactions could be done on each swatta, but it does not clear the slate of other existing claims. So I could sell my swatta, my claim, to someone else, but that did not wipe off the slate for other people. Now, three propositions of this property of Indic holding had been retained in Indian law. One is the HUF, Hindu undivided family. One is the Devattar, whereby the deity can hold land, whereby the temple lands could be held, an idol or deity could hold land. And the third is the whole concept of land to the tiller, or the claim of the land to the tiller. The tiller having a claim to till the land. Till today, the law does not recognize claims on common lands and lands held by villages and to a lesser extent tribes. But this has been, I think, largely remedied by the Forest Rights Act. Now, right to property in the Government of India Act 1935 and the Constitution of 1950. Now, the Government of India Act was the last British constitution of this country, I'm sure, which you are aware. Now, in Article 298, it said that anybody can hold property, but special protection were given to agricultural tribes of specific areas. In Article 299, it said no person to be deprived of his property except by authority of law, and property could be acquired for public purpose. The reason, again, there's a large history of why they said property could be acquired for public purpose. The reason was because of the intermediaries, because British government was so beholden to the zamindars and the talukdars that there was this huge debate as to whether we should be able to acquire property for any purpose. But they realized that, because there was so much pressure from the zamindars and talukdars, so they said no, it has to be only acquired for public purpose. Article 300 specifically protected special protection of grants made to the zamindars. Now in the Indian Constitution 1950, all of us know 19(1)(f), right to acquire, hold and dispose property, subject to 19(5), reasonable restrictions in the interests of general public and scheduled tribes, which was before amendment. 31(1), no one could be deprived of property without authority of law. 31(2), property can be acquired for public purpose save by authority of law, and that law will have to provide for compensation or a mechanism to calculate. Subsequently, 31(2) was amended, and then 31(a) was added, 31(b) was added, before the property right was completely removed at the time of the Janta regime, and it was added as 300(a) as a constitutional right. Now, the Supreme Court had three phases. This is what I would like to sort of summarize it. Three phases. The first was the conflict phase, where Supreme Court was liberal and the legislature was socialist. So there was the Kameshwar Singh, where in relation to the abolition of zamindari, where the Supreme Court stood up for property rights, where Sholapur Spinning and Weaving Company was compulsory acquisition of shares, and the Supreme Court stood up against compulsory acquisition. The next phase was the compromise phase on nationalization. Stood up for compensation but accepted nationalization. If you looked at R.C. Cooper, which was the bank nationalization case, and the Supreme Court allowing the prohibition of the abolition of privy purses, Supreme Court came into this largely socialist mode. Now, post that, in the post-liberalization phase, Supreme Court is now again faced with the whole concept of property. So how does it deal with it? Because property now, there is this entire thing that property rights is an indicator of good governance. Supreme Court deals with it by reading in property as a human right. First, by the back door in the Indore Vikas Pradharikaran in 2007 in Justice Sinha's famous judgment, as a human right, and then exactly as what I was saying, as a right of the poor in the land acquisition cases of Justice Singhvi in 2011 and 2012. And a series of judgments, Justice Singhvi actually says that your right to property is actually a tool in the hand of the poor to resist the state from forcibly acquiring their property. There's been a huge amount of politics in relation to property. Pre-independence, it starts pre-independence. Mahatma Gandhi was a believer in the trusteeship and people having the right to property. The entire Congress was split into two groups, was Mahatma Gandhi on one side, Sardar Patel on the other. Sardar Patel, Mahatma Gandhi, Rajaji versus Bose, JP and Nehru. They were all against property. But Nehru's biggest move came when he tried to collectivize property. And that was Swatantra's heyday, when that entire move was resisted. Now with Indira Gandhi came huge amount of nationalization, but most importantly it was the Janta government which removed the right to property and made it into a constitutional right. Post-liberalization, the politics is still there, everybody can see it. There's been a politics of trying to acquire land and the failure of the land acquisition bill, and the single movement. Now, how do I see the future of politics of the right of the property to India? There is, of course, pressure on land. Land is required for industrialization, make in India, and so on and so forth. Without industrialization, there can be no progress. However, there's also pressure on agricultural land, because agricultural land is needed. People are India is buying land, getting lands in Africa to cultivate. And land is also a cultural and civilizational issue, and that is something which no one should ever disregard. Solution is possibly lease, possibly redevelopment of old lands which are not in use. Property rights as to nationalization seems to be settled. However, if anyone who's seen the Vijay Mallya case will also knows that property rights are now being misused by recalcitrant industrialists to avoid payment of legitimate dues. And so the banks are, taking away the right to property, because they are not paying. So, this is a this is a continuous evolving issue, and this is the last slide. Now, what do I see the right to property as a fundamental right, the future from? Property rights are important, but history has taught us that civilizationally and even for the rule of law, no property right can be absolute. The right to property is a tool of the weak and not a privilege of the poor. That is now increasingly being recognized. Taking it away as a fundamental right was a mistake because no one knows what is a constitutional right. But the right to property has to be adequately made subject to other restrictions and other fundamental rights. I personally would like more recognition of methodologies of indic property holding as part of property rights. Inclusion of conceptions of swatta and non-recognition of eminent domain. If we have to release, and this is my last bit, this is my conclusion, this is the provocative part. If we have to release the animal spirits, and a market system has to be truly representative, it has to be culturally and civilizationally close to its people, and less of rights of entitlements and more recognition of claims based on traditionalization of constitutionalism and property rights, property claims.
For me, a capitalization of a property would mean that we should be able to use the property like a free currency. There must be an ease of transfer, and it must be available to everyone. It could be transferred just as you transfer any other property, which would have no restrictions. When we talk of an immovable property, we have 5 modes of immovable property provided in our law, which would involve transfers, in which 3 of them mean transfer of property, as in the ownership. It could be gift, it could be sale, it could be exchange. There are limited rights which get transferred in a lease, and mortgage is something which is a right by which you can raise money for raise money for your business or for any purpose. That is perhaps what, according to me, would mean capitalization of the property. I will speak about what are the hurdles in the capitalization, give what I think are the possible solutions, and I leave it that, and give few illustrations on this. The biggest hurdle which I see in a capitalization of a property in India is there is a restriction on the use of land. Not every piece of land can be used for every purpose. Broadly speaking, we have divided land in 2 categories. One is called an agricultural land, and other, what in a common practice we call is an NA land, which means non-agricultural land. Within the non-agricultural aspect, we have 3 subcategories. One is called, it is for residential, industry, and for commercial activity. Residential, as we understand, you build your house. Industry, we all understand. And commercially, if you are setting up a shop or opening up a branch of a bank or anything else, that is what would be commercialization of the property. How do we overcome the situation what we face? I'll share few illustrations. In one of the instances in Uttar Pradesh, a particular educational trust was allotted land in excess of, say, almost about 100 acres of land, with a clear-cut restrictions that it will be used only for the purposes of running of educational institutions. So this means it comes with a rider that you have a land granted to you, allotted to you, but you can only use it for limited purpose, for educational and research purposes. Over a period of 15-17 years, the land which was meant for the purposes of raising of educational purposes fell in the heart of the city and came in what is known as R zone, which is like a residential zone. Running of a institute for education would not make sense there, but the restriction is you can't use the land for residential purpose, notwithstanding the fact that there may be a greater need of the land for residential activity. So this is an example where a residential land cannot be put to a use. This is a hurdle which we face here. As against this illustration I gave you pertains to state of Uttar Pradesh. As against this, certain states, particularly I am speaking of Madhya Pradesh and Rajasthan, wherein they wish to promote their industry. So the process what they have followed is that if you are using an agricultural land, if you wish to use a land for agricultural land for industrial purposes, all what you need to do is to inform the competent authority that this is an agricultural land and we wish to use it for industrial purposes. And there is an element of a deemed sanction. Nobody needs to stand in queues to get their land converted, as in get an agricultural land to an NA. There is an element of a deemed sanction. So if I look at it, these are two different phases in which the issue of restriction of land has been used, land use has been used. I understand there is some basis, there must be some basis. Industrialization is a priority. Similarly, education is a priority, but at this we need to draw a balance. That's what I would say, that which land could be used for which purpose is something which needs to be seen. These are two different illustrations of this. Then the second hurdle what we face in the country is that we have a land ceiling. A person, for the agricultural land, you cannot hold a land more than a particular limit which is prescribed by each state. It may vary from 50 acres in Rajasthan in a desert area to say 12 acres in an irrigated land in Punjab. Each state has its own set of land. Before I say something on a ceiling law, I'll say the reason why it is being done. Prior to the ceiling, when the India got independence, the farmers were in a bad position, so land reforms were brought in. So one of the land reforms were that a person should not hold more than a permissible limit, so the land is distributed to all. So there comes in a restriction of a land usage by each person. Now let us look at the practical problem here again. In Uttar Pradesh, we have something which is known as the UP Zamindari Abolition Act, which states that you cannot have more than 12.5 acres of land available to you. You cannot hold. Should you want to hold more than 12.5 acres, you have to take a prior permission. Here I would give you an illustration in a particular manner, in a particular illustration of a case where the landowners, for the purposes of setting of a copying machine, the Xerox copying machines, they acquired land directly from the Bhumidars, who are the landowners, in a range of something like 85 acres, whereas by law they were permitted to use it only for the purposes of 12.5 acres. As a result, the government, the Abolition Act says the balance, the Abolition Act, by the Abolition Act, only 12.5 remained with them and the rest vested with the government. So here it is this is where we face a difficulty in setting up of an industry. No industry or an educational institution can be set up in a land parcel of 12.5 acres. This is something which needs to be addressed. The available law for setting up of acquisition of land was a Land Acquisition Act up till 1894, which was an act where a government under the eminent domain could acquire, but that act has since been repealed, which has been replaced by another act, where the government encourages people to buy directly land from landowners, from the landowners, so that the government doesn't get into any difficulties with the people whose lands are acquired in the process, through the process of the eminent domain. Now the issue here is, if you buy it directly from the people, you can't buy more than a limited area. The government doesn't come to help to acquire land. Where is the solution? I don't have it here. Maybe this gathering would come out with some solution on this. The third challenge what we face in a capitalization here is the land records are totally unkept in this country. Land records, there is no uniform system of keeping of land record. Each state maintains its own method of keeping records. To say this as an extreme case, Karnataka as a state was carved out by joining 4 princely states together, and you'd be surprised they follow 4 systems of land record. There is no uniform method whereby the land records are kept so that they can be accessed from anywhere. Digitalization is a problem. Most of the digitalization has started only in 2005. So what we need to do is, according to me, the solution is there must be a common platform, common method of keeping the records in this country so that everybody understands it. It is kept in the native language, it is recorded in the native language, but there are softwares available by which it can be translated into another language. So something of this kind should be done for dealing with the land record part. The fourth aspect, these three are the aspect where there is an exchange of land, ownership gets transferred. The fourth aspect is when we see it from a banker's perspective. Bankers take properties as mortgage, as collateral. When we talk about those properties as collateral, as a part of our land reforms of this country, the government, the statute says mortgage of an agricultural land can only happen by way of a registered instrument. I may say that there are 6 methods by which a land could be mortgaged. The easiest method which is followed in the country, in the banking circle, is what in India we call as an equitable mortgage or mortgage by deposit of title deed. You go to the bank, hand over your titles, and it is accepted as a mortgage and the money is lent to you. Whereas if you go in for a registered instrument, the property you have to go to the office of sub-registrar, pay the stamp duty on the amount of the loan, the process becomes cumbersome. Therefore, this becomes a hurdle in a due diligence part because there is a restriction on transfer. Similarly, in Indian law, the women got the right in the property in 1956. Prior to that, women did not have the right. In 2005, we made further amendment by the women were further empowered. Typical to our system, women when the daughters get married, their names are not recorded in the land records. When their names are not recorded, when you go to buy that land, there is always a challenge. There is always a probability that there may be challenge by the daughters staking their right in the property. So that brings in a difficulty as far as the due diligence part is concerned. We need to do a due diligence for a period of 12 years if you have to acquire a private land, but if you wish to take a land which is not owned by any person, it belongs to the government, you need a due diligence for a period of 30 years. For me, the solution for this appears is, even if we start doing it now, let's start keeping the records nicely from today. 30 years down the line, the situation would be far better and we would not face this difficulty. Lastly, what I would say is that in around 2011, the government came out with something known as land titling bill, whereby the government, everybody was to get their land registered with the authority. The challenges would be invited. If no challenge is received for a period of 5 years, it will be believed that you are the owner of the property. And the government would issue a certificate to you that this land is has a good title and is free from encumbrances. If that happens, people would be happy to buy that land. Anybody investing in this country would be happy to invest in the country on those land where they get a certificate from the bank. This is something what is wanting here. That is all what I have to say.
By early 2000, the lives of the tribal population in most of India were similar to the poorest of the poor in India.
We came to a couple of villages and we saw their plight. Their situation was just like near starvation. They couldn't get 2 square meals a day. It was not a good situation.
At that time, no one really cared enough to think that there's one category of citizens who are really not enjoying the rights of citizens. And they were too poor, too disorganized to be able to express themselves in a manner that the political society would recognize.
But things did change. As economic reforms were erupting across the country, tribal communities and their advocates began to organize and speak out, laying claim to the lands on which they were living.
People protesting, marching, coming to Delhi. In fact, there was a Million Men March to Delhi. What dawned on the political establishment was they realized that there is a genuine demand and something has to be done. They didn't suppress it in the way they could have or would have 20 years ago, 30 years ago, or 50 years ago.
Things seemed to change in 2006 when the national government passed the Forest Rights Act, which included a provision for tribal peoples to gain legal rights to their traditional lands. Ramabai and his family live in Sagai village in the national forests of Gujarat. Rama is a farmer and a tribal leader in the village.
બધે પાસે એમ કરતા કરતા બધાને વાત તો હમણાં કે કાયદા આવી ગઈ હશે ને 2005 પહેલાની જમીન આપવાનું છે હવે 2 જણનું નામે થશે પણ
But there was a catch. In order to gain ownership of their land, villagers had to prove that they were farming a specific parcel prior to December 31st, 2005.
In situations like these villages, there is no one who's recording who's farming when and how. How would you prove that?
પછી એમ થઈ પછી બધાના પેલા અરજીઓના પેલે ફોર્મ મેળવેલા જાતિનો દાખલો જરૂર પડશે એટલે બધા દાડામ દોડ થઈ ગઈ પછી દાખલા કાઢ્યા ને બધે તૈયાર કરે અમુકના તો જે એમ નકશો નથી લીધા ને એટલે અમુકના આશરે ક્ષેત્રફળ કરે અમુકના આપણા મોટે ભાગ તો દોરીથી માપેલો તેમાંથી જ કરે.
But the application and hand-drawn maps weren't enough. The government insisted on an official paper trail with a history of government-issued documents proving ownership.
નથી મળી પહેલા થોડાક મંજૂર હતા એટલે તે પહેલી વખતે નથી મળ્યો પછી હમણાં પછી બધાનું ના મંજૂર કાઢી દીધું.
After a lengthy review process, the government only approved 10% of the applications. It looked like most villagers were back where they started. But then they came up with a new idea. What if they could use satellite maps to prove that the villagers were cultivating specific plots of land prior to 2006?
So the satellite images on Google Earth was one instrument by which we thought it's possible. So what happened was that archival images became available. So in some places we have images from 2002 and 2004, which means that you get a picture of the history. So if in 2005 you see this forest, you know this was a forest. If it was an open field, you can see that on the image. So if you see that boundary, there is no way you can deny that this plot was being farmed. And there was no other way to show it in such a dramatic manner as the satellite image.
10-15 people from each village sat around those images, trying to make heads and tails out of them. But once they got their bearing, they could identify each person's fields on these images.
The next critical step was to create accurate boundary maps that could be superimposed over the satellite imagery. Small handheld GPS units provided an easy solution.
You switch it on, get the satellite signal, walk around the perimeter of the field that you want to map, transfer it to a computer. You'll be able to see the plot boundary on the image and you'll know where it has gone.
And you see what was the condition of this particular piece of land in, say, if the image is of 2005, whether it was under forest or it was under cultivation. You can easily see.
Now, tribal villagers had definitive maps to bolster their applications. With the GPS data in hand, nearly 90% of their applications for legal ownership were approved by the government. Years of hard work had finally paid off.
This technology has really been a boom. If the law was passed 10, 20 years ago, these technologies didn't exist. So people would have had to struggle to prove and help implement the law. This was a classic example of how society was mobilized, political sensitization took place, the law got enacted, and the technology converged to help facilitate implement the law.
Now they are no longer encroachers. They are no longer criminals. These people are now very confident that now we own this land. And that has snowballed into so many other things.
મારી જમીન હવે બંને નામે કોઈનું ખેડવાનું આપવાનું નથી, કોઈને વેચવાનું નથી, આપણે પોતે જ મહેનત કરો. અને એમાં પાછું જો આપણને જે લાગતો હોય ને થોડુંક શેડા પર હોય કોઈ પણ શાક અથવા આંબો કે કોઈ બી વસ્તુ રોપી દેવાનું, તેના કરતાં થોડું થોડું ઢાળવાળી હોય જમીનમાં તેમાં પણ આંબાને એવા કોઈ રોપી દેવાનું.
How do you capitalize? Capitalization, or the problem of poverty, is primarily an issue of our inability to capitalize. The extent of land conflict is something that Amitabh Bachchan at one end and poor, remote, rural farmers at the other share the same bond. Because of the problem of titling, problem of exchanging, and what Anupam said, the capitalization problem is linked to how the land is going to be used, like you said, Anurag, right? That how and who has the capacity to decide how a land to be used, and that's where the money is being made. Which is why a friend and I, we estimated a few years ago that 1 to 2% of India's GDP is being generated through underhand or under the table transactions related to land and property. This is a problem none of us can escape. The question is, how do we move from where we are today to where we want to head? Thank you very much.
Did you come across any examples of implementation of torrent system? Because I think it is being implemented in some parts of Rajasthan, and if you did come across, then what were the experiences?
If we are talking of the Rajasthan's latest law earlier this year, where they had a kind of a title guarantee, I don't know how it has worked so far, but to my understanding that law is for urban Rajasthan, and I have a problem. I would really like to see if they'll be able to implement in urban areas at all, because the property valuation in urban India is very high, the gap, the differential between rural and urban. Given that, who will be able to pay the assurance that has to be paid in order to work out a title guarantee? You know, what is the idea of a title guarantee? Title guarantee is, we know that we have a problem with the land records, which means Anupam may possess the property, Anurag may own it. How do we resolve this issue? Typical resolution is you go to the courts. But in an Indian court, we are unlikely to get a justice in our lifetime. Excuse the lawyers. But what the title guarantee is supposed to do is, with least dislocation, it says he can get the right with a nominal transaction. He gets a compensation which may not be a full market, but some compensation compared to he gets nothing now. He has the compensation, he is happy. Who is going to pay this? I mean, that means somebody has to pay the money. Typically in Western countries where this has been tried, either the government pays from a central fund or an insurance company pays. Insurance companies will pay if the quality of title records are very good. Where you have only 1% problem, they would be very happy to pay. In a country where we have a title records problem of 75-80%, no private insurance is likely to come in the short term, which means the government will have to pay. The question is, given the price differential, will the government have that kind of money to get into title guarantee in urban India? My thought at that time when it came was that perhaps it would be a good idea to try it out in rural India, where the price differential is much less, and demonstrate the viability of the model before getting into urban India, because apart from the valuation, urban India has the highest amount of litigation on property. So he won't like to give up so easily if he has the title, and he won't like to give up the possession if he has the possession. Yeah.
I'll just take, this is the classic Singur conundrum. The government acquired, I'm sure you're all aware, the government acquired actually all the land from the title holders, and then there was a complete revolution of the sharecroppers, and people who were the landless tillers just went on a complete revolution, brought down a communist government of 35 years. So this is a problem, and this is a problem which I think is not a new problem. It is a problem, I agree, with land titling because of the fact that we haven't recognized traditional methods and claims of on land. Until you actually do it, you will face the continuous problem, whether we like it or whether we don't, because the Land Acquisition Act, the Transfer of Property Act, the titling of is barely 200 years old. And unless you recognize the fact that, like property, like everything, it's a barely 200 years old creation. So, you have to recognize the multiple claims on the same land. Until you do that, it's never going to work. It is going to work as long as it's backed by the force of the state. And it's worked for the British. The British acquired this entire city by the force of the state. Fine, you can do that, you can remove them. But today I can also guarantee you there are Waqf claims pending before the court, whereby people claim that though this land has been acquired, this is Waqf, so this is protected. And this Waqf claim goes back 500 years back. In the city, barely 100 meters from this place in Jorbagh, there is this huge dispute as to Waqf, which created riots happening on that. So, you have to realize this. You can't live in a bubble. Property laws, like any laws, has to take into account your civilizational background. It's not going to take off otherwise.
I think it's a huge opportunity today. The ground has shifted. The question is, can we find a lever through which to push up? I can't believe that today we are talking of property rights in a manner which 20 years ago, 30 years ago would have been impossible. And it's happening from the bottom. So I think the ground has shifted.